Welcome to this deep dive brought to you by Sinorbit Academy, Sri Lanka. Today we're focusing on the institutions of the European Union and, crucially, how you can effectively study them for your University of London exams.
That's right. And just a reminder, the materials we're exploring today are those made available to students by the University of London, strictly for educational purposes.
Absolutely. So good luck, everyone, with those exams. Let's dive in.
We're heading straight into the core of the EU, looking at those key institutions laid out in Article 13 of the Treaty on European Union, the TEU.
And our mission today.
Well, it's not just about listing them. We want you to understand how they function, how they interact, and really importantly, how you should approach studying this topic for your exams.
So we're using the University of London's Topic 3, the Institutions of the European Union document as our guide. We'll pull out the essentials, the must-knows.
Exactly. Think of this as your focused prep session. We'll highlight the key concepts, the vital treaty articles, and those landmark cases you really need to remember.
Okay, let's start at the beginning then. Article 13 TEU. This sets the whole scene, doesn't it?
It absolutely does. Article 13 is your starting point. It formally lists the EU's key institutions. Just having them listed there, right in the treaty, underlines their fundamental role and their established powers within the EU legal order.
So their authority comes directly from the treaties.
Precisely. It's not just assumed.
Okay, so who's on this list? Which institutions are we talking about?
Article 13 TEU names 7. You need these clear in your head. The European Council, the Commission, the Council, that's the Council of the EU, remember the European Parliament, the Court of Justice of the European Union, which includes the General Court, then the Court of Auditors, and finally, the European Central Bank, the ECB.
7 key players. Got it. The document mentions a single institutional framework. What's the significance there?
That's a really important concept. The single institutional framework in Article 13 means these 7 bodies aren't just separate entities doing their own thing. They're interconnected, part of one system. And underpinning this whole framework is the principle of conferral. You'll hear that a lot.
Conferral, meaning?
Meaning the EU institutions only have the powers specifically given or conferred to them by the member states in the treaties. They can't just grab new powers for themselves.
Right. The member states ultimately decide what the EU can do.
Right.
So for studying, how should you approach learning about these 7 institutions?
The University of London Guide suggests, very wisely I think, tackling them one by one. Look at their origins, their composition, who's in them, their main functions, and, crucially, their specific powers. Let's start with the European Council. This is the big one, where the heads of state and government get together.
The European Council, the top table, where the major political decisions happen.
Exactly that. And it's interesting, it wasn't always a formal institution. It actually grew out of informal summit meetings between national leaders back in the 70s, becoming more formalized after 1974. These meetings are where the really high-level political direction is set and where difficult issues between member states, like arguments over budget contributions, often get resolved. Think high-level strategy.
So they set the EU's overall direction.
Precisely. Article 15 TEU states its main role, providing the Union with the necessary impetus for its development and defining the general political directions and priorities. It's made up of the heads of state or government from each EU country, plus the President of the European Council, the President of the Commission, and the High Representative for Foreign Affairs and Security Policy attends as well.
Okay, for exam purposes, what's the absolute key takeaway for the European Council?
The number one thing to remember is its political role. Despite its huge influence, the European Council does not make laws. It doesn't have legislative power.
No lawmaking.
No. That's the job of the Council of the EU, which we'll get to. So, European Council, political direction, yes. Legislation, no. Keep Article 15 TEU in mind for that. And also remember, the President of the European Council. Article 15, Paragraph 5 TEU outlines their job. Elected for 2.5 years, renewable once, chairs the meetings, drives the work forward, represents the EU at that head of state government level.
Got it. Political strategy, not laws. President chairs and represents. Okay, let's switch to the European Parliament. This institution has really changed over time, hasn't it?
Oh, massively. The EP's journey is quite remarkable. As the UoL material points out, it started back in 1957 as essentially a consultative assembly, a talking shop with very limited influence. But fast forward to today, and it's a co-legislator with the Council in most EU policy areas. It has real power to shape, amend, and even block laws. Plus, it has significant oversight functions, understanding that evolution is key.
From talking shop to real power. So what are its main jobs now?
2 core functions, much like national parliaments. First, enacting legislation, usually alongside the Council of the EU, and second, scrutinizing the work of the other EU institutions, holding them accountable.
And who makes up the parliament? Who are the MEPs?
They've been directly elected by EU citizens since 1979, which is a huge source of its democratic legitimacy. Article 14 TEU sets the maximum number of MEPs at 751. Seats are allocated based on digressive proportionality.
Digressive proportionality. What does that mean?
It means larger countries have more MEPs, but smaller countries have proportionally more representation per citizen. So a Maltese citizen's vote counts for more, proportionally, than a German citizen's vote. There's a maximum of 96 seats per country and a minimum of 6. Remember that term? Digressively proportional.
Okay, digressively proportional. Got it. And how do MEPs organize themselves to get work done?
They don't sit by nationality. Instead, they form transnational political groups based on shared ideology, socialists, conservatives, Greens, liberals, and so on, from different countries working together. The detailed legislative work happens in specialized standing committees focusing on different policy areas like agriculture or environment. The Parliament also elects its own president and sets its own internal rules of procedure under Article 232 TFEU.
So it's not just grand debates. What specific powers does it have beyond legislation?
Good question. Under Article 226 TFEU, it can set up temporary committees of inquiry to investigate alleged contraventions or maladministration in the application of union law. It also appoints the European Ombudsman, that's Article 228 TFEU, who investigates complaints about maladministration by EU institutions. That's a key link for citizens.
Ombudsman, yeah, that's important.
And Article 227 TFEU gives EU citizens the right to petition the Parliament directly on matters within the EU's field of activity. So remember the Ombudsman and the right to petition, they show the EP connecting with the people.
Strasbourg, Brussels, Luxembourg. You mentioned its location is a bit spread out.
Yes, it's quite unique. The main plenary sessions are generally held in Strasbourg, France. Committee meetings and political group meetings are mostly in Brussels, Belgium. And the Parliament's administrative staff, the Secretariat, are based in Luxembourg.
Why so complicated?
Historical and political reasons, mainly. Attempts to consolidate it in one place have always run into opposition from the countries involved. There are key court cases on this. Luxembourg v. EP and France v. EP re-Brussels meetings. Essentially, the court upheld this arrangement, acknowledging the political sensitivities. So remember those cases when thinking about the EP's slightly nomadic existence?
Right, those cases confirm the slightly awkward setup. Now back to that power evolution. How did it get from just being consulted to being a co-legislator? This sounds crucial for exams.
Absolutely critical. Initially, the treaties often just said the Parliament had to be consulted, but the Court of Justice stepped in early on to give that meaning. The Roquette-Furs v. Council case is the one to remember here. The court ruled that consultation wasn't just a formality. If the treaty requires consultation, it's an essential procedural requirement. Meaning, if the Council adopted legislation without properly consulting the Parliament when required, that legislation could be annulled, struck down by the court under what's now Article 263 TFEU. So, Roquette-Furs established that the Parliament's opinion mattered, even back then.
Roquette-Furs failure to consult equals potential annulment. Got it.
Then came the Single European Act in 1986. That introduced the cooperation procedure, giving the Parliament a second reading and more ability to amend proposals, but the Council still had the final say. It was a step up, but not equality.
Okay, cooperation was better, but still not equal footing.
The real breakthrough was the Maastricht Treaty in 1992, introducing the co-decision procedure. This was significantly strengthened by the Treaty of Amsterdam and later renamed the Ordinary Legislative Procedure by the Lisbon Treaty, found in Article 294 TFEU. This is the game changer. The Ordinary Legislative Procedure makes the Parliament a genuine co-legislator on an equal footing with the Council for the vast majority of EU laws. This shift is fundamental. Remember Article 294 TFEU and its significance.
Co-decision becoming the ordinary legislative procedure. That's the big leap. Equal partners with the Council for most laws now.
In most areas, yes.
Hey.
And its influence extends beyond lawmaking. Think about the appointment of the European Commission.
How does that work?
The Parliament has to approve the European Council's nominee for President of the Commission. Then, the entire proposed team of commissioners of the College must face a single vote of approval from the Parliament before they can take office. This gives the Parliament considerable leverage over the EU's executive.
So they approve the president and the whole team.
Yes. And they can also fire them. Article 234 TFEU gives the Parliament the power of censure. A motion of censure, if passed by a two-thirds majority, forces the entire commission to resign.
Has it ever happened?
It almost did. The Santer Commission resigned en masse in 1999 under threat of censure following allegations of mismanagement. So that power of censure under Article 234 TFEU is very real, even if rarely used to its final conclusion.
Wow, a powerful check. And how does Parliament keep tabs on the Commission day to day?
Through scrutiny. They can ask the Commission written and oral questions, which the Commission is obliged to answer under Article 230 TFEU. The Council also generally answers questions, though it's less formally obliged. This questioning is a constant form of democratic oversight.
Okay, key takeaways for the Parliament. Its journey to co-legislator status, direct elections, scrutiny powers, especially over the Commission's appointment, and the Article 234 censure power. And remember, Roquette Frere and the shift to Article 294 TFEU.
Right, let's move to the Commission itself, often called the EU's engine room. That's a good description. The Commission's unique role as the UoL material stress is to represent the interests of the Union as a whole, independent of national governments. Its functions are incredibly varied. It proposes legislation that's huge. It acts as the guardian of the treaties, ensuring member states comply with EU law.
Guardian of the treaties. Sounds important.
It is. It involves investigating potential breaches by member states under Article 258 TFEU. The Commission also enforces EU competition law, think Articles 101 and 102 TFEU. It adopts delegated acts, manages the EU budget, implements policies, mediates between member states and the Council sometimes, and represents the EU internationally. It's a real powerhouse.
Okay, so proposer, guardian, enforcer, executive, a lot of hats. How is it structured? Who are the commissioners?
There's one commissioner from each member state. And Article 17, Paragraph 3, TEU emphasizes their independence. They must act solely in the Union's interest, not taking instructions from their home country or anyone else. They serve a 5-year term, mirroring the Parliament's term.
One per country. Strictly independent. How are they appointed? You mentioned the Parliament's role.
Yes, it's a multi-stage process showing those checks and balances. First, the European Council proposes a candidate for Commission President, taking election results into account. The European Parliament then elects this candidate by a majority. Once the president is elected, they work with the member state governments to select the other commissioners. This whole team, the college, then needs a vote of consent from the European Parliament.
So the Parliament gets a say on the president and the whole college.
A very significant say. After Parliament's approval, the Commission is formally appointed by the European Council. The president then assigns portfolios to the commissioners and appoints vice presidents, including the High Representative for Foreign Affairs.
And if the Parliament doesn't like a particular commissioner candidate during that process,
Technically, they only vote on the college as a whole. But politically, if the Parliament signals strong opposition to an individual nominee during the confirmation hearings, that nominee is often withdrawn or replaced. It shows the Parliament's de facto influence.
okay. And inside the commission, we hear about the president and the DGs.
The president is very much in charge. They set the policy direction, coordinate the work, decide the internal organization, assign portfolios, and can even ask a commissioner to resign. The administrative backbone is made up of directorates general, or DGs, and services. Think of these like government departments or ministries, DG Agriculture, DG Competition, DG Trade, etc. Each DG is headed by a director general reporting to the relevant commissioner. This is where the detailed policy work and implementation happens.
DGs are the engine room within the engine room then. Let's go back to that guardian of the treaty's role. Article 258 TFEU.
Exactly. Article 258 is key. The Commission monitors member states' application of EU law. If it believes a state isn't meeting its obligations, it can start infringement proceedings. This usually starts with dialogue, trying to resolve it informally. But if the member state doesn't comply, the Commission can take the case to the Court of Justice of the EU.
And if the court rules against the member state?
If the state still fails to comply with the court's judgment, Article 260 TFEU allows the court, on application by the Commission, to impose financial penalties, lump sums, or daily fines. This is a serious enforcement tool to ensure EU law is respected. So remember, Articles 258 and 260, crucial for enforcement.
Real teeth there. What about enforcing competition law, Articles 101 and 102?
Yes, the Commission is the primary enforcer here. It investigates companies suspected of anti-competitive practices like cartels or abusing a dominant position. It can make legally binding decisions, finding infringements, and impose very large fines. It's the EU's main competition watchdog.
And the power to propose law is the right of initiative.
Yeah.
That really shapes the EU agenda, right?
absolutely fundamental. In most areas, new EU laws start life as a Commission proposal. While the Council and Parliament can ask the Commission to propose something under Articles 241 and 225 TFEU, the Commission generally holds the pen. It drafts the proposals that go to the Parliament and Council for the ordinary legislative procedure. It also sets out its priorities in an annual work program. This power of initiation is a major source of the Commission's influence.
But can the Commission make laws itself unilaterally?
In some very specific limited areas, yes. The treaties grant it direct legislative power, for example, under Article 45(3)d or Article 106 TFEU. The case France, Italy, and United Kingdom v. Commission explored the limits of this. There's also the concept of implied powers, recognized by the court in cases like Germany, France, Netherlands, Denmark, and the United Kingdom v. Commission. If the treaties give the EU a task, the institutions implicitly have the powers needed to carry it out. And importantly, the Commission adopts a lot of delegated legislation, detailed rules, filling out framework laws passed by Parliament and Council. So, primarily an initiator, but with some direct and delegated lawmaking powers too.
Delegated and implied powers, good concepts to grasp, and its executive role, implementing policies.
Yes, it oversees how EU policies are put into practice by national authorities, ensuring consistency. It also manages the EU budget alongside the Parliament and administers huge funding programs, especially in agriculture and regional development.
And it speaks for the EU internationally.
That's right. It represents the Union in trade negotiations and in many international organizations, acting on behalf of the member states in areas of EU competence.
And finally, that Article 234 censure power we mentioned earlier with the Parliament.
That's the ultimate accountability. Parliament can force the whole Commission to resign. The 1999 Santer Commission resignation under threat of censure is the key example to remember. It shows Parliament's political oversight power in action. Remember Article 234 and Santer.
Okay, Commission, initiator, guardian, executive, representative. Powerful, but accountable. Lots there. What about the High Representative? That sounds like a complex role.
It is unique. Article 18 TEU sets it up. The High Representative for Foreign Affairs and Security Policy is appointed by the European Council with the Commission President's agreement. They wear two hats, double-hatted. First, they conduct the EU's Common Foreign and Security Policy, CFSP, as mandated by the Council. Second, they are a Vice President of the Commission, responsible for coordinating all the EU's external actions.
So they bridge the intergovernmental foreign policy side and the Commission's broader external relations.
Exactly. They chair the meetings of EU foreign ministers, the Foreign Affairs Council, and are supported by the European External Action Service, the EU's diplomatic corps. It's designed to bring coherence to the EU's voice on the world stage.
Interesting role. Okay, let's move to the Council of the EU. Easy to confuse with the European Council, but distinct, right?
Absolutely vital to keep them separate in your mind. European Council heads of state government setting political direction. Council of the EU expect government ministers from each member state meeting to legislate and make decisions. The Council of the EU, often just called the Council, represents national interests. It's the main legislative body, now sharing that power with the European Parliament in most areas through the ordinary legislative procedure.
So when we say the Council, we mean national ministers.
Yes. Which ministers attend depends on the subject. Agriculture ministers for farm policy, finance ministers for economic issues, and so on. Unlike the European Council's permanent president, the presidency of the Council of the EU rotates between member states every 6 months. The country holding the presidency chairs meetings and drives the agenda. They work in trios with the preceding and succeeding presidencies for continuity.
A rotating presidency.
Yes. And the General Affairs Council helps coordinate the work of the different council formations. The whole operation is supported by a General Secretariat based in Brussels, mentioned in Article 240 TFEU.
We often hear about CORBIPR. What's that?
CORPER, the Committee of Permanent Representatives. Crucial body. Since ministers can't be in Brussels all the time, CORPER does much of the preparatory work. It's made up of the member states' ambassadors to the EU. They meet weekly, negotiate on behalf of their governments, and try to reach agreement on legislative files before they go to the ministers.
So they do the groundwork.
A huge amount of it. Items agreed in CORPER often go onto the Council agenda as A points adopted without debate. Contentious issues needing ministerial discussion are B points. There are 2 parts. CORPER 2. Ambassadors deal with political, financial, external affairs, and CORPER FI, Deputy ambassadors handle more technical, internal, market, social, environmental issues. They're supported by numerous working groups of national experts. Understanding Corpor's role is key to understanding how the council really works.
Corper, the engine room of the Council, and the link between the Council of the EU and the European Council.
European Council sets the strategy, the big political goals, but it doesn't legislate. So the Council of the EU, usually with the Parliament, takes that political direction and turns it into concrete legal acts. Think Article 7 TEU on rule of law breaches, Article 48 on treaty change, Article 50 on withdrawal. The European Council might make the initial high-level political decision, but the Council of the EU handles the necessary follow-up steps or legislation.
Okay, Council of the EU, national ministers, main legislator with Parliament. Corper does the prep. Got it. Last institution on the Article 13 list. The European Central Bank, ECB.
Yes, the ECB. Absolutely central for the Eurozone countries. Its main job is managing the euro, the single currency, and defining and implementing monetary policy for the euro area. It's based in Frankfurt, Germany. It's part of the wider European system of central banks, ESCB, which includes all EU national central banks.
And who runs the ECB?
Key decisions are made by the Governing Council. This consists of the 6 members of the Executive Board, the President, Vice President, and 4 other members, appointed by the Eurozone leaders, plus the governors of the national central banks of the Eurozone countries.
Independence is vital for central banks. You hear that a lot. How does that apply here?
Hugely important. Article 130 TFU guarantees the ECB's independence. It explicitly forbids the ECB or national central banks from taking instructions from EU institutions, governments, or anybody else.
Why such strong protection?
To ensure monetary policy decisions are focused solely on maintaining price stability, free from short-term political pressures that might lead to inflation. Credibility depends on independence. So remember, Article 130 TFEU independence is paramount.
And its main goal?
Article 127 1 TFEU states it clearly. The primary objective of the ESCB, and thus the ECB, is to maintain price stability. That's number 1. Without prejudice to that objective, it also supports the general economic policies in the Union, aiming for things like sustainable growth and high employment. The ECB also has legal personality and a specific standing in court procedures under Article 263 TFEU. But price stability is the core mandate.
Okay, ECB, managing the euro, monetary policy, independence, Article 130, primary goal of price stability, Article 127.
Exactly. So we've covered the main institutions. Now, crucially, we need to understand the laws they create and the processes they follow. The sources of law, the types of acts, the procedures.
Right, the EU's legal output, treaties, regulations, directives. It can seem complex.
The UoL materials break it down clearly. You have primary law, the treaties themselves, the top of the legal hierarchy. Then secondary legislation, the laws made by the institutions based on the treaties. Then there's the case law of the Court of Justice interpreting EU law, general principles of law the court recognizes, and international agreements the EU signs.
And for secondary legislation, Article 288 TFEU is the place to look.
Absolutely fundamental. Article 288 defines the main types of EU legal acts. Regulations, directives, decisions, those are the binding ones. Plus, recommendations and opinions, which are non-binding.
Let's take the binding ones. Regulations.
Yeah.
Directly applicable. What does that mean in practice?
Directly applicable is key terminology. It means an EU regulation automatically becomes law in all member states as soon as it enters into force at EU level. No national implementation measures are needed, or even allowed if they obscure the EU nature of the law. The aim is uniformity across the EU. The court has stressed this in cases like Commission v. Italy, re-slaughtered cows, variola, Busson, and crucially, Simmenthal, the case establishing the supremacy of directly applicable EU law over conflicting national law. Regulations also generally have direct effect. Individuals can rely on them in national courts. So, regulations, directly applicable, uniformity, direct effect, Simmenthal supremacy.
Uniformity, automatic effect. Got it. Directives are different, though they need national implementation.
That's right. Directives set an objective or result that member states must achieve by a certain deadline, but they leave it to each country to choose the form and methods how they transpose it into their national legal system. This allows flexibility for different national traditions. The big issue arises when a member state fails to implement a directive correctly or on time.
What happens then?
The court developed the principle of direct effect for directives too, but with conditions. If the deadline has passed, and the directive's provisions are clear, precise, and unconditional, individuals can sometimes rely on it directly against the state or emanations of the state, public bodies. This is vertical direct effect. Key cases here started with the general principle in Van Gendon Loos, though that was a treaty article. Then Van Dyne, Ratty, Marshall, which confirmed direct effect is only vertical for directives, and Foster, defining emanations of the state. So, directives need implementation, flexibility, potential vertical direct effect if unimplemented. Remember Ratty, Marshall, Foster.
Okay, so citizens might get rights against the state from an unimplemented directive. And decisions.
Decisions are binding in their entirety, but unlike regulations, general application, they are usually addressed to specific entities, a member state, a company, an individual. Think of a commission decision, finding a company for breaking competition rules. But remember, the international fruit case, the court looks at the substance, not just the label. What matters is if it's intended to have binding legal effects on those it addresses. So decisions binding specific addressees, substance over form. International fruit.
And recommendations and opinions, non-binding but influential.
Exactly. No legal obligation, but national courts might consider them when interpreting EU or national law. They offer guidance.
The UoL material also mentions other types of acts, acta sui generis.
Yes, the Article 288 list isn't exhaustive. The court has recognized other institutional acts can be binding if they're intended to produce legal effects. Lever ve EP is crucial here. It established that acts of the Parliament intended to have legal effects could be challenged in court, leading to Article 263 TFEU being amended. Commission v. Council, URTA, showed even a council resolution could have legal effects. It's about the intended impact. Remember Lever and URTA.
Not just the label, but the legal intention. Okay, how are these laws actually made? The procedures. You said the ordinary legislative procedure is dominant now.
Yes, Article 294 TFEU. This is the default procedure for most EU lawmaking now, putting the European Parliament and the Council on an equal footing as co-legislators. It replaced the old co-decision procedure. Understanding its steps is vital.
Okay, walk us through the ordinary legislative procedure. How does it work?
It starts with a commission proposal sent to both Parliament and Council. Parliament does its first reading, adopts a position, possibly with amendments. The Council then examines Parliament's position. If it approves all amendments, or if there were none, the act is adopted.
But what if the Council disagrees?
If the Council doesn't approve Parliament's position, it adopts its own common position and sends it back to Parliament for a second reading, explaining its reasons. At second reading, Parliament can approve the Council's position, act adopted, reject it, act fails, or propose further amendments.
More amendments, then what?
If Parliament proposes amendments, it goes back to the Council. If the Council accepts all of Parliament's second reading amendments, the act is adopted. But if the Council doesn't accept all the amendments, a conciliation committee is convened.
Conciliation committee.
Yes, equal numbers of MEPs and Council representatives, with the Commission mediating. Their job is to try and agree on a joint text within a strict time limit, usually 6 weeks. If they agree on a joint text, it goes back to both Parliament and Council for a final approval, third reading. If both approve, the act is finally adopted. If they fail to agree in conciliation, or if either institution rejects the joint text, the whole proposal fails. It's designed to force compromise.
A multi-stage process, quite complex. Visualizing those readings and the conciliation step seems key for studying.
Definitely. And remember Article 296 TFEU, the duty to state reasons. Every EU legal act must explain why it's being adopted and, crucially, specify the treaty article providing the legal basis.
Why is the legal basis so important?
Because the legal basis determines which procedure applies ordinary legislative procedure or perhaps a special procedure giving one institution more power. Using the wrong legal basis can lead to the act being annulled by the court. Cases like BASF, AGV Commission, and Commission v. BASF touch on procedural requirements. Getting the legal basis right is fundamental.
Okay, legal basis dictates procedure. Get it wrong, and the law could fail. Finally, the principles of subsidiarity and proportionality. Article 5 TEU.
Yes, Article 5 sets out these two key principles governing when and how the EU should exercise its powers, especially in areas where competence is shared with member states. Subsidiarity means the EU should only act if the objectives can't be sufficiently achieved by the member states themselves, at national, regional, or local level, and can be better achieved at EU level due to scale or effects. It's about acting at the most appropriate level.
So, only act if the EU level adds value.
Essentially, yes. Proportionality means that even if the EU can act, the measures it takes must not go beyond what is necessary to achieve the treaty objectives. The action must be suitable and the least burdensome means to achieve the aim. There's a protocol attached to the treaties explaining how these are applied, including a yellow card system where national parliaments can object to a draft law on subsidiarity grounds. So Article 5, subsidiarity, act at right level, and proportionality, don't go too far. Important limits.
Subsidiarity and proportionality, key checks on EU action.
Absolutely. Understanding them helps frame the whole legislative process.
This has been incredibly thorough. So boiling it all down, what are the absolute must-knows for someone preparing for their UoL exams on EU institutions?
Okay, key focus points. 1. Know the roles and main powers of the 7 Article 13 TEU institutions: European Council, Parliament, Commission, Council of the EU, CJEU, Court of Auditors, ECB. 2. Understand the evolution of the European Parliament, especially its rise to co-legislator status under the Ordinary Legislative Procedure, Article 294 TFEU. 3. Get crystal clear on the different legal acts in Article 288 TFEU regulations directly applicable. Directives need implementation, vertical direct effect issues, decisions, specific addressees. 4. Remember those key treaty articles we flagged: 5, 13, 15, 17, 18, 127, 130, 226, 228, 230, 234, 250, 288, 294, 296 TFEU. Have a basic idea of what each covers. 5. Know the landmark cases: Roquette Frere, Luxembourg v. EP, France v. EP, Simmenthal, Van Genton, Luce, Radi, Marshall, Foster, International Fruit, Lever, ERTA, and the others we mentioned relating to specific powers or procedures. And 6. Grasp the meaning and application of subsidiarity and proportionality under Article 5 TEU. Nail these down and you'll have a very solid foundation.
That's a fantastic checklist. Really highlights the need to engage with the UoL materials and focus on these core elements.
Definitely. And as a final thought for you to consider as you study, how has this evolving balance of power between the institutions affected the EU's democratic legitimacy and its overall effectiveness? Which part of this complex institutional machinery do you think is most significant today, and why? Thinking about those bigger questions can really deepen your understanding.
A great question to ponder. Thank you so much for guiding us through that complex landscape. And thank you all for joining this deep dive. We hope it helps with your exam preparation. Remember, this is brought to you by Sinorbit Academy, Sri Lanka, using materials provided by the University of London for educational purposes. Good luck with your exams.